but how does one then take them along in further giving flesh to the notion of progressively realizable rights? And the Constitution, as well as the government, will have to do a lot of work in thinking through this very carefully. I do think that when it comes to issues of substantive equality, which Vincent raised, and special temporary measures, there is a fair amount of to be learnt, particularly in the way CEDAW and CERD decisions and general comments and conclusions have been implemented in certain concrete cases. CEDAW certainly has taken the notion of substantive rights fairly ahead, and we could learn some very important lessons from that. The point made by Vincent around, substantive as opposed to formal equality, in providing equality not merely of opportunity, but equality in outcome, becomes very critical, particularly in the context of disadvantaged communities. Also, equality, equal wages for equal work is a slogan that we have been following, but especially in the context of women's work, where difference comes in, and we look at special measures, then perhaps we could move a step further and talk about equal wages for work of equal value, rather than equal wages for equal work, but work of equal value. This, of course, places an extra burden on the state and on the government and on state authorities in trying to see what is work of equal value. But for disadvantaged communities, and especially gender, this becomes a very critical point. And my friend Mario. So I'm not going to reinforce those, but merely recognize that the very fact that the CA and the constitution making process is taking note of economic, social, cultural rights and struggling with this is a very, very significant step forward. And we all need to put our thoughts together in giving force to these and in making them enforceable and justiciable. Thank you very much.
And again, he has also emphasized on the progressive realization that is to come into the future, and the substantial issues are to be given a due shape so far as the concept of equality is concerned, because equality is, of course, the real equality. If the outcome of equality is observed in the society, so is her notion. I thank her once again, and now I duly request Advocate Dr. Bhimarjun Acharya to have his presentation so far as his comment is concerned before the House or floor.
My fellow commentator, Jyoti, and ladies and gentlemen. Within 10 minutes of time, I will be covering very few my remarks and comment with regard to socio-economic rights. One would be the constitutional dynamics of socio-economic rights in the context of Nepal, how the constitutional document has protected these rights. At the same time, I would also be talking the very politics engaged in the enforcement and guaranteeing the socio-economic rights. And the third issue, I would be commenting on the progressive realization clause as slightly incorporated by Dr. Mario and Vincent. And the fourth one would be the enforcement mechanism so far we have adopted in interim constitution, and it is proposed for the new constitution. I think all of you know that there is a politics in the world, including in Nepal, in the name of socio-economic rights, focusing the rights of the marginalized people and minority rights. And the Nepal is no exception to this. If you see very constitutional dynamics of Nepal in this context, we adopted the first constitution in 1947. This was the first written constitution of the country. And this constitution for the first time had guaranteed right to equality and right to property to Nepali people. I remember that the document was adopted 1 year before the adoption of UDHR in international community. In 1948, December 10, UDHR was adopted, and it gave some recognition to some of the basic human rights of the people. 1 year prior to the adoption of UDHR in 1947, we, the Nepali, had adopted Nepali constitution, and for the first time it guaranteed right to equality. And there was I think you know that there are at least two facets of equality clause. One is the equality before the law, and second one is the equal protection of law. I don't have to elaborate much about equal protection of law. It gives the whole avenues and whole space on the part of government and state to take a positive measures so as to implement and guarantee the basic rights of the people. I must say, unfortunately, the provision was not so far in force in the country, and we had another constitution in 1950. So this way, till the date, we have adopted 6 constitution, and again we have been talking and we have been crying for the rights of socio-economic and etc. But now, one thing I very honestly say is that even we have a constitution, and the constitution gave some recognition to socio-economic rights, why the people of Nepal, particularly Dalits, Janjati, and other people, could not get the enjoyment of these socio-economic rights. The one reason is that the politics involved in this case. So I have seen, though all over the world, not only in Nepal, is that there are at least 2 opposite trends in regard to this thing, one thing. One trend is particularly confining with the demand of socio-economic rights and talking of socio-economic rights for the cause of a struggle for power. Political players and state actors, they have used this slogan to achieve their political power, and unfortunately, people have not been benefiting from the guaranteeing rights of socio-economic. If you see on the part of the people, say, take the example of Dalits, Janjati, and etc., that who have been facing and who have been suppressing from the state for the last century, their demand for asking socio-economic right is the struggle for social justice. You know that social justice, or you say justice, as is said by John Rawls, is the first virtue of a state where there is a equitable, or you say equal distribution of benefits and burdens. But because of this very unfair politics engaged in the name of marginalized people and in the name of, you say, socio-economic rights, you people still have been depriving from the enjoyment of these rights. So this is one facet that you have to be known, very well known about the situation of Nepal while guaranteeing these rights. Engagement, and the state must have performed some sort of action so that the right be materialized. But at the same time, one clause, as you international people or international community have used in international document, that guarantee the socio-economic rights on the part of the people. But I say, and one of the very landmark decision, judicial pronouncement, aggressive realization, our court has categorically stated that, for example, progress which were produced before the Supreme Court of Nepal, seeking for the enforcement of socio-economic rights. Meaning also when there are severe resource constrained actors, they have taken this clause, so-called progressive realization. I have to talk on this part. And the third aspect I will say is that sometimes we activists, we jurists, and we lawyers, we speak of the socio-economic rights and we forget the nexus between economic rights and the economic freedom. So socio-economic rights cannot be achieved. But now the part of economic freedom aspect is respected by the Constitution. You are not going to have a full sense of socio-economic rights. What I have understood is that, for example, I have proposed rights. I think that could be complement to present people to decide for themselves what is best for their own well-being, and make freedom could be the state should recognize that there is very much imbalanced discussion regarding these things. On the one hand, you have been disrupting the activities of industries and the factories. How can you under obliged to follow those conventions? But the thing is that the very concept of collective bargain to secure their rights. But on the one hand, freedom and the rights of the investor has not been fully secured in the state, you can't enjoy socio-economic rights. So this is the second aspect. And then secure environment, protect private property and the value of money, and the basic component of socio-economic rights. But this part is of the CA members in fundamental rights, you say draft of the fundamental property has to be restricted, and the state should be given the property. There is a provision of right to property, but concerning with the, you say, the use of private property for the cause of public use is debatable and controversial, and there is a controversy regarding the compensation clause also. And the next one is the freedom of business and trade, freedom of investment, labor freedom, freedom from corruption and government manipulation, etc. For your information, last year I published one book that was entitled Fundamental Rights in the World Constitution, and I had made a comparative study of some 135 countries. I think the most of the, I have seen some of the participants from those countries. And what my learning is that, for example, I found some of the constitution which has very rarely discussed about the socio-economic rights, and some have their balance between economic freedom and socio-economic rights. So the countries which have the balance in the constitution between socio-economic rights and economic freedoms, they have a great achievement in the economic sector, and the country has been very much prosperous. So I think this is the need of the country. Otherwise, you see, we people have been fighting for democracy for the last century. But our whole democracy is dependent upon the political values, and we have not given the much emphasis and talk about social democracy and the economic democracy. I think this is the right time that we have been writing the constitution in the 21st century. That's why this aspect must be respected in the constitution. So my final now comment is that with regard to the interpretation and enforcement clause, as was tossed by Dr. Vincent, but for your kind information, I would say that we have adopted the dualistic model of the implementation of international law here in the country. You know that, like in USA, we have a supremacy clause of Constitution under Article 1, and that says that the Constitution would be supreme document. And there is a contradiction between this constitutional provision and Section 9 of Nepal Treaties Act, which talks of the monastic model of the implication of international law. But so far, there is a provision of Article 1 which talks of the supremacy of Constitution. All international laws are subordinate to constitutional framework so far the Nepali jurisprudence is concerned. So international law first needs to be domesticated in the country, then they can be enforced. Though I'm not saying is that Nepal doesn't have obligation to comply the international provision which it has been given a signature. But the thing is that we have a very clear jurisprudence that jurisprudence is dualistic model of the implementation of the international law. And similarly, we have a very strong judicial review provision. For your information, I wrote my PhD thesis on this system of judicial review. And this is something hybrid between US model of judicial review and the Australian model of judicial review. And Supreme Court has been given the exclusive authority to enforce the fundamental rights and to interpret the Constitution and law. Unfortunately, the very recent judicial review report, judicial committee report produced in the parliament has proposed that the parliament will be the final authority to interpret law and constitution. I have a very much disagreement and reservation on that part. We have a constitutional supremacy, and under constitutional supremacy, no other institution, including judiciary, can be prevail or can be supreme above the constitution. So this is the very position. And finally, some of the very important suggestion has been put forward by Dr. Mario. But for your information, for example, the new draft includes that we have a proposal to right to live with dignity, and this has been proposed in this draft. This is, I appreciate this thing. And similarly, so far the enforcement mechanism is concerned, yeah, right, you have introduced one, you have issued one jurisprudential question, for example, either the socio-economic rights can be enforced against private sectors or not. I think this is debatable not in Nepal, but this is debatable all over the country. But we have a two school of thought regarding this. Some activists say that fundamental rights must be enforceable even against the private entities. But some strictly believe that no, fundamental rights are always directed against the state. That's why they cannot be enforceable against the private entities. So these types of two school of thoughts are there in our country. So for the litigation model, you have said that we have a provision and we have a very great practice of third parties intervention. For example, today there is a hearing of one controversial issue in the Supreme Court. General Thoran's case is there. I am one of the lawyers, and after this my presentation, I am going to plead before the court. And now in this issue also, for example, some of the civil society and human rights organizations have come up with the Supreme Court for third parties intervention. So we have a great practice of third parties intervention with regard to the enforcement of fundamental rights which are guaranteed in the Constitution. So far you have been talking about the independent mechanism to monitor and supervise the implementation of court order. Now this issue is very much controversial in Nepal. Some jurists believe that, for example, if these types of mechanism has been set up, then there would be the threat to the independence and
he has trusted upon that is of very, very important. And if the judicial creativity that we require to maintain in the society, judicial activism, then the prominence role of the judiciary is a must to be given a shape so far as the process of constitution making is concerned. So these ways he has put forward so many things for our knowledge and information. I thank him for his so nice and critical approach to the understanding that he has contemplated. So he has completed his comments. Now I open the floor to have the discussion forward. And for this, I have one mandate that you should not take more and more time by going beyond 3 or 4 minutes.